she sort of took umbrage why those issues were raised. So in those meetings, I think the issue was, a decision has been taken, matter is authorized, it's going to proceed as she's directed.
And then the last one, in this commission, your investigators, Mr. Padiaki and Mr. Chief Perumal, have been accused of what on the face of it is serious misconduct that may well amount to fraud. The commission has not made findings one way or the other because we must hear all sides. But the allegations are that they created affidavits many months after, and then they backdated the affidavits to create the impression that those affidavits were deposed to on the 6th of January 2025 in relation to Mr. Adams's supplementary affidavits, and then in relation to the Section 27 affidavit. The allegation is that the affidavit that has been provided to the commission and the one that we as commissioners have been looking at was only created after October 2025, and it could not have existed in November 2024 when Mr. Adams made the referral to IDEC. Now you as head of operations and head of investigations, when you hear allegations like those, did you make inquiries internally to find out what the position is? And if the commission has been misled and has been provided fraudulent documents?
Chair, my recollection is I heard of these allegations when these matters were ventilated here at the commission. I think Mr. Rapesu would have indicated that he suspects there is something wrong that would have happened with the Section 27. And if I remember his words was, but the truth will come out. So I remember speaking with Chief Perumal, if he knows anything about this, and then he says, no, there's nothing like that. Everything it's on board. And I took his word for it.
Lastly, and it's a question Chair asked, because you are the head of investigations, is it common, is it usual within IDEC that an investigator can start an investigation and conclude the investigation without having seen the Section 27 referral? Because Mr. Padiaki told us that that's what happened in this case. He never saw the Section 27 referral.
Chair, in terms of our processes, and the manual also speaks to that, when a matter is authorized and the project manager convenes a project meeting with all stakeholders, including the DDPP, all information relating to that matter is shared and discussed within the team. It is an anomaly for those documents not to be shared within the team. It is clear that on this matter, there was exception to the rules.
Should it also have formed part of the application for a warrant of arrest, the Section 27 affidavit? So when IDEC applies for a warrant, should the Section 27 have been attached to the affidavit that was placed before the court? How does it work in practice?
In practice, the investigating officer will draft an affidavit, basically outlining the investigation conducted and the offences that,
because
that are alleged to have been committed.
Sorry to interrupt you. Because the starting point is the Section 27 referral, does he attach it to the affidavit?
No, in practice it's not.
He doesn't do that.
In practice it's not.
But it forms part of the docket.
In practice it's not.
So in practice, it does not form part of the docket. You
No,
don't even share it with the accused.
No, it is part of correspondence, internal correspondence, but it's not attached to the docket.
And when they ask for it because they want to challenge IDEX jurisdiction or IDEX mandate, how do you deal with that?
Well, when they ask for it, in my experience is that it has been provided when they had asked for it.
So, Mr. Sesoko, when a docket is opened or when an inquiry is opened, doesn't the Section 27 become the A1 statement? And then it can be supplemented if there's anything further to add to the affidavit. How does it work at the start of the investigation? Assume that the investigation has been authorized, either in terms of 28.1 or 28.13, and then a docket or an inquiry is opened. Shouldn't the Section 27 affidavit be the A1 statement?
In practice, Chair and Commissioners, the Section 27 referral is treated differently. When an investigation starts, when it's authorized, then the complainant is approached for an A1 statement, and a full comprehensive A1 statement which would address all the elements of the offense is then obtained. And that is what is used as the A1, not the Section 27.
Where does one find that? Is that in the manual or is it your interpretation?
It's the practice.
But where does one find that? Where is it recorded that that's the practice?
I'm not sure if we record it like that in the manual. I must be honest. I'm not sure if we do that. I think the manual states the processes that must be followed, but it does not specifically say what happens in relation to Section 27 or an A1 statement, because it's more of an investigative operational issue that investigators do.
And the reason we are asking this is because Mr. Peter Serunia, and Ms. Remsemi, they have testified in this commission that, and I hope I'm not confusing their evidence and the transcript will bear that out, but they said the Section 27 affidavit becomes the A1 statement, and then any further statement obtained from a witness supplements the Section 27. So the Section 27 is not an internal document. It is the genesis of the investigation. It is the affidavit that must set out what offense is being reported and what offense must be investigated, so that what the investigator looks at and what guides the investigating officer is in fact that affidavit.
Chair, I won't dispute that it may happen in other matters, that, you know, the Section 27 may have been included as an A1, you know. But I'm talking in generality what I know would have happened in most of the matters.
But because IDEC has not had that many Section 27s, you
Yes.
said so yourself,
Yes.
most of your matters are from the commissions,
Yes.
and there was that general authorization from the former ID. Don't you think this is something that should be clarified in the manuals?
Yes, certainly, Chair. I mean, this experience with the Commission, it's a lot of lessons learned for us. We already having a discussion internally about IDEC reset and how we improve our operations and including our manual so that we are all clear in terms of processes, because this process has shown the weaknesses within the organization that really need urgent attention.
And these weaknesses are serious because they can lead to systematic failure.
It is
they
true.
can impact not just IDEC, but other law enforcement agencies, as you have seen with crime intelligence and SAPS.
That is true, Commissioner. Lessons learned.
Thank you.
Can I? Can I just check? You say in paragraph 59 you don't seek to know its details, and this relates to the principle of being neutral. But surely that position in practice does not apply to the ID.
Yes, it does. It does not, Commissioner, because she's the ultimate person that takes decision on all these matters. A matter cannot be enrolled without her approving that. So every decision of this nature, it is taken by the ID.
But then by same, well, not same, you are head of investigations. It seems to me you should know what's happening in investigations.
Yes.
So that rule, if it's a rule in the workplace, should not be applying to head of investigations, because you need to be able to speak to the investigations that are happening in your organization.
That is correct, Commissioner. And in most matters, that's what had happened.
Yes.
As I said, this was an exception.
So in a properly working IDEC, a person in your position who is head of investigations is supposed to know and be involved with investigation. When I say involved, I don't mean you run and do the investigations,
Yes.
but you, because you're the overseer
Yes.
of all the investigators and of investigation, so you should know this.
That is correct, Commissioner.
Okay. Therefore, it must mean I'm trying to determine whether it's this a person problem that you ended up in this position where you don't know about investigations that are happening because they're being directed by the ID and who chooses Mr. Perumal, Mr. Pariachi, and others. Is it a problem that a different head of investigation would have been correct to say, I'm head of investigations and I will not be excluded from investigations? Or it's a misunderstanding of your role by both you and the ID that you are also subject to that rule of practice, that you don't need to know what's happening in matters. I think, put simply, is this a structural problem? Is it we happen to have the wrong people in the positions. We had the wrong ID in the form of Ms. Johnson, who did things the way that she did and excluded you, or we had or we had a wrong head of investigations who didn't assert his role and position when he gets excluded. Can you just say which one it is? And the question is important because at least from where I'm sitting. Because among the things that the Commission is required to do is to make recommendations, including recommendations about what improvements, changes need to be done to the organization. So we are going to have to grapple with how did IDAC land where it is today? Is it a structural problem? Is it that whoever employed Ms. Johnson just made a bad decision? Whoever employed Mr. Sesoko made a bad decision? You understand what I'm saying? What I'm asking you. Can you just comment to that?
Chair, the fact of the matter is, in this particular instance, rules were not followed. And I took a decision at that point in time, as I explained in my affidavit, based on my personal history. I take full responsibility that I should have acted differently. But at the time, for me, it was the right decision to take, given the considerations that I've said to the Commission.
I understand, and thank you for that answer. It's trying to understand whether, what's behind my question, whether in terms of your contract of employment, which sets out what your job is, you could have asserted to the ID, even if she didn't like it, you could have said, there is no investigation that will happen that I don't know anything about. Does your contract, the terms of your contract, give you that kind of standing, or it's a problem in the contract because maybe she still gets to make decisions finally about investigations? I'm trying to understand that. So I'm trying not to make it personal to you, but to understand what are the limitations other than your personal circumstances. Another head of investigations, will they not find themselves in exactly the same position for different reasons?
Chair and Commissioners.
Perhaps to add to that, besides the contract of employment itself, or in addition to that contract, there are the annual performance, what do you call them, which you sign with your boss, undertaking that you are going to perform in accordance with, and then, as I understand it, there's itemization of all of everything that you undertake, you are going to do during that year. Am I correct that there is such a thing? What is it called?
That is correct. The performance agreement.
Yes. Now, I'm adding to what Commissioner Baloyi says, which is a reference to the employment contract itself, and I'm saying there's also this performance agreement. Would what you are required to do not also be, it would obviously be included in that, and would it cover what Commissioner Baloyi is raising, and if it would, what would you be assessed on if not on that? That is what it covers, which includes the issues that Commissioner Baloyi is raising. At the end of the year, how do you get assessed if you've not said, now if you do not allow me to do A, B, C, D, how am I going to be assessed at the end of the year? So basically that contract would require of you to raise the issues that Commissioner Baloyi is referring to. Now can you please respond, with all of that in mind, can you please respond to Commissioner Baloyi's question?
Thanks, Chair. My performance agreement provides that I must advise the ID. As I've indicated that these matters were discussed and should take a particular position. I understand the concerns, and in hindsight, maybe I should have taken this issue even further and not let it be as I did. But that's what, to me, at that point in time, seemed right to do. As I said, that maybe I should have acted differently by raising this issue at a higher level, so that what now has been ventilated here could have been stopped. I do, however, I am, however, not sure if it would have made any difference.
Sorry, you may carry on.
No, I was saying that I'm not sure, however, if it would have made any difference.
You say you're not sure because the ID is the person that she was, or what? Because you see, you speak of, you say your contract says you advise the ID. The next question is, well, what does that mean in fact? You advise her on investigations that your people are doing and what they put together as it before she makes a decision. Does advising mean that you say to her, on this investigation, there's no case? She ultimately, gets to sign off on the next steps. But what does advising her entail?
Advising the ID, it means advising her on all operational issues. Where matters are under investigation, what are the challenges, what needs to be done. Most of the time, what happens in practice is that decisions like enrollment and so forth would happen when there has been a meeting of all stakeholders to discuss that matter, and when there is a consensus that the matter must be enrolled. But my advisory role is where there are issues of that affect the project, so that we can discuss how we overcome those issues. In relation, for instance, to these specific issues that are raised here at the Commission, there would have been discussions about it to say there are issues that have been raised. There is concerns about these things, and she would give that direction to say, no, I'm satisfied about these things. This matter will go on. If there has to be a takedown, the takedown must go on.
You see, from the evidence, say, let's take the Mokwele matter, that it has appearances, even we haven't made any final decisions, but concessions made by the witnesses. There seems from those concessions to be an acceptance that there were shortcomings in the investigations, at least one area. There were shortcomings in the investigations. The question that it prompts for me is, where was the head of investigations when there were these bad shortcomings, these serious shortcomings, and the matter gets J50 issued, people get arrested and they go to court? Where was the head of investigations when this happened, where a poorly investigated case lands at people getting arrested and people getting to court? Even before that, it lands at a decision to prosecute. Now, from your answer, it's still not clear to me that things got that bad because the head of investigation was missing in action for reasons that you give. Or look at the perimeters of my powers, my position. I can't do more than forget that I didn't tell the ID maybe, but if you look at my contract, I can't do more than just saying, ID, this investigation is poor, the matter is not ready to go to court. In the end, she makes the decision, because if that is the case, it may well be that recommendations or thought must be given to how do you give the head of investigations more power, or ensure that in their contract they get to make determinations about investigations, and they're the ones that sign off to the ID to say, yes, I'm happy with the investigation, and until there is that sign off, the ID may not approve, may not give a decision, or may not sign off. I'm trying to get you, to assist us in answering that kind of question. And I must say that in your answer, the way you've answered, I haven't gotten the kind of assistance that I'm looking for, or the answer to my question.
I understand, Commissioner. The reality of the matter is that this investigation was directed from the ID's office, not from my office. All decisions relating to it were directed from that office, including the takedown. I learned of it after the fact, when in normal circumstances, when you conduct a takedown, we sit in a meeting, discuss how that takedown would look like, whether there's a warrant of arrest to be applied for, or HA 175, all those issues. That was not the case in this specific matter. So it was an unusual situation, and I think that's the best way I can answer you, Commissioner.
Would you consider as an appropriate suggestion that I put to you, that the system, the structure has to be such that the ID should not be immersed in the investigations, should not be directing investigations, because ultimately her people must satisfy her when she make him her. When they make the decision now, as they're empowered to do, starting with the 2813, right? 2813. The ID should be sitting as a neutral party, so to speak, where others come and persuade her, we need a 2013, and then she can interrogate what they're doing at that point. And then they go and do their work. Now she must authorize an investigation. She should not have been involved in the process of directing, go find this, go find that, because ultimately when they come to her to her in this case, because it was a her, for a 28-1, she must look at it with a fresh eye, with an unbiased eye, if you like. The same for all the various stages that she must authorize. Would you consider it an appropriate suggestion that the ID should in fact be insulated from all of that, so that by the time she's required to exercise the statutory powers of being the ultimate decision maker on the different steps, she looks at things with a new eye and an unaffected eye?
Commissioner, I agree totally. In fact, most of our matters, that's how they have been conducted. She would come at a very tail end. And as I said, that when those meetings happen to discuss where now the team says the matter, the investigation is complete, now we're ready to enroll. And that's how in most matters it would have happened, except for this one.
Maybe the exception suggests that it should be an entrenched position in
Yes.
respect of which no ID has an option to deviate, and there's no exceptional matters, because all matters that come to IDEC must meet the criteria, so they cannot be exceptional and sensitive matters that only the ID should look at.
That is correct, Commissioner, and that's what motivated me to create the case intake criteria.
Okay. Part of the concern you have raised, or an explanation that you have given for not escalating things to the NDPP, you shrugged your shoulders, and we've had evidence as well that where matters have been escalated to the then NDPP, there was no good outcome out of it, and people seem to have ended up in worse positions than they were before they lodged the complaint. How do you suggest to fix for that kind of problem? Is it again a matter of, well, it's about the integrity of the people that you appoint, or it's a problem in this scheme that we have, where you have IDEC falling under the NPA, and ultimately the NDPP is the one that people must escalate things, but the NDPP has a working relationship with the ID because they all belong to the same organization. Is that the problem, and does, in your view, the appointment of the judge, IDEC judge, and whatever his terms of reference are, create a different playing field than what you had when it was just ID and NDPP?
Commissioners, I think, unfortunately, the issue of the judge came much later, even though it was provided for in the legislation. I think it took time to be implemented. I would venture to say that had it been in place much earlier, some of these issues would have been raised with the office of the judge, and maybe there would have been interventions much earlier.
Do you say that because the terms of reference of the judge?
Yes.